Hearing in the Queen on the application of the Association of Independent Meat Suppliers and another against Food Standards Agency.
Thank you, Mr. Hockman. Good morning.
My ladies, my lords, may it please the court. Good morning, my lady. Your ladyship and your colleagues, I'm sure, are aware of the representation, so I will...
We are, yes. So there's no need for you to say that. There is, however, something that we would like to draw to everybody's attention. It may or may not be a good point, but it is a point which has occurred to a member of the court, which we think it only fair to put before you all right at the outset, because if it's got any merit in it, it has serious implications for your case, Mr. Hockman, in particular. It may or may not have any merit. We wish to explore it with you. And so Lord Sales is going to explain what it's all about.
Morning, Mr.
Good morning, my lord.
The issue that we'd welcome your assistance on arises from Regulation 854 2004, which is tab 3 in the statutory primary authorities. And the question is whether the official vet is an agent of the competent authority for the purposes of the operation of the regulation and the legal regime more generally. So if one looks at the definitions in Article 2, which is MS page 829 and 830, one sees the definition in Article 2.1f of the official veterinarian. He's a veterinarian qualified in accordance with this regulation to act in such a capacity and appointed by the competent authority. Then G, approved veterinarian, means veterinarian designated by the competent authority to carry out specific official controls on holdings on its behalf. And then official auxiliary is a person qualified in accordance with this regulation to act in such a capacity, appointed by the competent authority and working under the authority and responsibility of the official veterinarian. So it seems that under the scheme of the regulation, if someone is acting on behalf of the competent authority, it says so. And then when one goes through the regulation, obviously there's a reference in recital 9 to the official veterinarians. They have a specific table of qualifications that they have to satisfy in Annex 1. And then under the scheme of the regulation seems to distribute responsibilities between the competent authorities in certain provisions, for instance, Articles 3 and 4, and on the official veterinarian in other provisions, for instance, Article 5 and under specific provisions of Annex 1. And the reason that, and so the question is whether it's right to regard the official veterinarian as part of the competent authority, or is he, once appointed, an independent officer with his own responsibilities and functions to fulfill. And the reason for raising that issue is that when one goes to Regulation 882/04, on which you particularly rely for parts of your argument, one sees recital 43, which is MS page 894, which says operators should have a right of appeal against the decisions taken by the competent authority as a result of the official controls. So focusing on the competent authority. And in Article 54, again, a provision on which you rely, again, Article 54.1, this is MS page 935, when the competent authority identifies non-compliance, it shall take action. And then Article 54.3, the competent authority shall provide the operator concerned with written notification of its decision, that is the competent authority's decision, and information on rights of appeal against such decisions. So you can see why we're concerned to get clear in our own minds what the status of the official veterinarian is. Is he part of the competent authority, or is he an officer with independent authority and responsibility under the scheme of these regulations?
My Lord, I hope you'll forgive me for making the observation at the outset. This is the first time that any question has been raised in relation to this.
Yes.
In particular, the FSA, if I may call them that, have never raised this as a difficulty in relation to our application for judicial review. They are undoubtedly the authority in question, and if there was a point to be raised on the difference between the authority and the official veterinarian, which I understand your Lordship is questioning, very properly, if I may say so, one would have expected them to raise it. I make that point, that obvious point.
I think that's why my Lady Hale was particularly concerned that this point should be ventilated at the outset, because we're looking to you for assistance. We're also looking to the respondents for assistance. There may be a short and simple answer to it.
Yes. Well, on the face of it, the answer to it is, in part at least, contained in the definitions that to which your Lordship has referred on MS page 830, and your Lordship has quoted them. That seemed to me to be at least going some way towards demonstrating that the official veterinarian is acting on behalf of the competent authority, and therefore provisions relating to the competent authority apply to him. But, my Lord, I wonder if I could deal with the matter in this way, because in the 2.5 hours allotted to our side, we have a lot of ground to cover in addition to the point your Lordship has raised. So what I would be inclined to do, if I may, is to suggest that we should proceed in the following way, that I should develop my argument over the next couple of hours or so, which is what I had intended to do, hand over to Mr. Hercock towards the end of the morning to deal with what I might call the property points. And then, no doubt, over the midday adjournment, my learned friend and I can have a discussion about the point that your Lordship has raised and see if we can at least reach some common ground in relation to it. I think it would be a little bit too time-consuming if I were to, as it were, on my feet, attempt to develop any further answer. I don't mean in any way not to take your Lordship's point seriously, obviously, and to provide in due course an answer to it, perhaps ideally a consensual answer, but if not, our submissions. But I'd rather not develop it further at this point, if that's convenient.
No, that's very convenient, yes. Thank you, Mr. Hockman.
Thank you very much. Where I was going to start is as follows, that in this case the court will once again be invited to clarify the law as between state and subject. In this case, as between a regulator, the FSA as I shall call them, and those whom they regulate, namely food business operators, whose businesses are critical to the economic and physical well-being of the country. More specifically, the issue relates to the so-called official controls carried out by the FSA in order to monitor compliance with food safety standards. In particular, the issue relates to decisions made by the official veterinarian as to whether meat is fit for human consumption, such decisions being inevitably an expression of opinion by the OV, if I may use that abbreviation. The case for the appellants is that in those rare cases where the FBO, the food business operator, that's the operator of the slaughterhouse, disagrees with the opinion of the OV, the law provides a process of challenge or appeal or review. The Court of Appeal has held that although this process undoubtedly applies in many cases of non-compliance, at any rate where such non-compliance is or may be due to a deliberate act of an operator, it does not apply in a case in which such non-compliance is entirely unintentional and arises simply because, on inspection of a meat carcass, the OV expresses the opinion that it is unfit, a decision which I think everybody recognises will have significant financial consequences for the FBO. It is this interpretation of the law by the Court of Appeal which we have been given permission to challenge in this court. The position of the FSA on these matters has, as we submit, varied from time to time. For many years, their official position, at any rate to go by the Manual of Official Controls published by them, was, we say, in alignment with our own, and acknowledged expressly that the review process upon which we rely is applicable in cases such as the present. More recently, and at around the time when the present judicial review claim was instituted, the FSA withdrew the manual and put forward a different position, which I will refer to in due course. And finally, during the course of the proceedings, the FSA themselves have, as they say, voluntarily introduced a mechanism whereby the OV has a discretion whether or not to take into account a second opinion provided by another vet, but the decision remains one for the opinion of the OV and is not subject to independent appeal or review, as we submit the law requires.
Would it be subject to judicial review, Mr. Hogan?
I'm sorry, Madam.
Would the decision of the OV be subject to judicial review?
Well, my Lord, the short but not entirely accurate answer to that question is yes, because that's what we're doing. That's why we're here today. We issued judicial review proceedings in relation to that decision. But that's because there was a point of law involved, namely whether there was a right to challenge under Section 9. There would be the right to issue judicial review on the footing that there's a point of law. Once the point of law has been resolved in this court, then the answer is no, because on the approach of the FSA, it is a matter simply for the opinion of the OV, and as it were, as a direct consequence, at any rate, of the decision of the Court of Appeal, judicial review is excluded.
So if the OV had taken a bribe, there would be judicial review.
I mean, there must be some scope for judicial review if an OV was abusing his position or was taking account of irrelevant considerations and so on. But your point is that the real dispute is whether there's anything wrong with this meat, and there is no independent review or appeal process, and judicial review cannot address that.
My Lords, thank you. I don't need to go as far as to say that judicial review would be excluded in all circumstances, and I don't go as far as to submit that. Those are very special cases, so one would hope, and I don't think I need to make any submission about those at all, save to acknowledge your Lordship's point in that respect. I do see that completely. But in relation to the normal operation of the system, the point we stress is this is a matter for the opinion of the OV. Either the law provides for an appeal, as we say it clearly does, as the FSA accepted that it did for many years until roughly the beginning of the proceedings, or there is no such right of challenge, and at that point the law would have to take a step back. Mr. Hercock and I, therefore, will seek to advance before this court 4 main submissions. The first is that directly applicable EU regulations do mandate the appeal process, or at any rate are certainly not inconsistent with it. The Court of Appeal, as you've seen, criticised me for not taking this as my starting point, and so before this court, this will be my first main submission. I hope...
Oh, that's so risky, Mr. Hockman.
Well, my lady,
but never mind.
All advocacy involves risks.
Yes.
That's one of the reasons why we do it. Before this court, this will be, as I say, my main submission, and my first main submission, and I hope to demonstrate as you might expect, that whether one starts with the EU regulations or with domestic law, the end point, which is what really matters, the end point, the destination, is the same, namely that for which we contend. And I respectfully remind the court, if I may, and I don't intend to refer to this again, but just to flag it up now, that if, despite my best efforts, it remains unclear whether, as a matter of EU law, this is correct, conceivably even the point raised by my Lord Sales could come within this category, but if it does remain unclear whether, as a matter of EU law, this is correct, the court can, at least until the point of our departure from the European Union, whenever that may be, make a reference to the Court of Justice, which is something that we would invite the court to do in the event of it being unclear.
Do you say we're bound to in those circumstances?
Exactly, my lord, yes. The second main submission that we make is that under domestic law, there has for many decades been a right of challenge or appeal or review, a matter which the domestic legislation demonstrates unequivocally, and that the meaning of the domestic legislation did not undergo a transformation in 2005 or 2006 when the applicable EU regulations came into force, a transformation which, if it occurred, went unnoticed for many years, not only by the industry, but by the regulator itself.
You're going to go on making that point. We've got it.
Thank you. I'll refer to it once more when we get to the document. Your ladyship will allow me that, I think.
Of course.
Those are the two main arguments which it will be for me to develop. Our third submission, a very brief one, which I can perhaps describe as a backstop, is that if we are wrong in our identification of the domestic law provisions giving rise to an appeal, then at any rate the EU regulations mandate an appeal procedure of some kind, and the court should make a declaration to that effect. Our fourth submission is that an appeal is mandated by other provisions of EU law and or by the Human Rights Act, and that fourth argument will, I hope, be developed by Mr. Hercock, to whom, as I say, I hope to give way sometime between 12:30 and 1 o'clock, when we have to sit down. So turning to my first submission...
Sorry, could I just ask you about your third proposition, the
Yeah.
backstop? If the EU regulations mandate an appeal procedure, why would a declaration be sufficient? Are you saying that there would need to be something done in domestic law to introduce that procedure?
Yes.
But if a regulation which is directly applicable mandates, says that there has to be an appeal procedure, then wouldn't you get your appeal under that regulation? I mean, it's directly applicable law if it's a regulation.
Yes. Well, my lord, I suppose, again, the short answer is yes, but what we would seek from what we have sought from the courts in our original claim, and what we still seek, is a declaration that that is the position. That's the relief that would arise under that particular submission. And it, as your lordship, if I may say so, rightly points out, it would then be a matter for others to decide whether such an appeal process was to be achieved by further legislation, an amendment to the legislation, or indeed, as I think your lordship was implying to me, whether it would be put in place administratively and without any further change in the law. All those possibilities are open. A change in the law would not be precluded, a change in domestic law, because of course, and again, this is something I don't think anyone disputes, it is by no means uncommon for an EU regulation to express a duty on the state, for example, in fairly general terms, and then for there to be domestic implementing legislation. accepting, of course, that a regulation is directly applicable, unlike most directives, nonetheless, it's by no means uncommon to find that one has domestic law, very often subordinate legislation, which, as it were, puts flesh on the bones of the directly applicable EU law regulation, and we see that in this case, and we'll come to it, the 2013 regulations, for example.
Thank you.
If we could turn, please, to volume 1, the EU law materials, and to tab 1, and I'll take your lordships as efficiently as I can through this material, accepting that you may already have had an opportunity to look at it. So, starting, please, at tab 1, Regulation 178 of 2002, which lays down general principles of food law, and turning, please, to MS page 714, where we find that Article 1 is saying that the regulation aims both to protect human rights and consumers' interests and to ensure the effective functioning of the internal market. We also see that food is defined as, this is Article 2, food is defined as a substance or product intended to be or reasonably expected to be ingested by humans. That element of intention is important, as we shall see as we go along. At page 715, MS 715, we see further important definitions. The definition of food law, the laws, etc., governing food in general and food safety in particular, covers any stage of the production, processing and distribution of food. We see the definition of food business, which includes a slaughterhouse, and we see the definition of food business operator. Then at 720, in Article 14, appears the rule that food shall not be placed on the market if it's unsafe, that food is to be deemed unsafe if it's considered to be injurious to health and unfit for human consumption. And note that our submission is, please, that the fact that food may not have been placed on the market, on the one hand, or may be unfit, does not preclude it from being food. And you will have seen that it has been expressly conceded by the FSA in this case that the relevant carcass was to be categorized as food from the moment of slaughter onwards. And even after being declared unfit by the OV. The reference to that, we don't need to go there because I've quoted from it, is MS 184, which is part of the respondent's written case. At page 722 is the requirement in Article 18 that food must be traceable at all stages of production, processing and distribution. And at 723, over the page, top of the page, that food placed on the market must be adequately labelled or identified to facilitate its traceability. Those provisions, it's top of 723. Those provisions are helpful in understanding what the health mark is really for, on which our opponents in particular place such emphasis. So that's 178. Moving, if I may, swiftly on to Regulation 853 at tab 2, which lays down hygiene rules for food of animal origin. Note, please, once again on the subject of traceability, at 751 in the preamble, paragraph 15, traceability of food is an essential element in ensuring food safety. In addition to complying with 178, FBOs shall ensure that all products of animal origin that they place on the market bear a health mark or an identification mark. So in the context of traceability. And then at 757, the same requirement, albeit somewhat differently expressed in Article 5, 757, an FBO shall not place a product of animal origin on the market unless it has a health mark. The recital in paragraph 15 that I've mentioned being clearly relevant to the purpose of that provision. Now we come, if we could please, to tab 3, Regulation 854, which lays down rules for the organisation of official controls on products of animal origin intended for human consumption. Note, please, that the phrase official controls is not defined in Regulation 854. What 854 does is to adopt the definition of official controls in the fourth and final regulation that we'll be looking at, 882, and that is achieved by means of what you can see on page 830, MS page 830. And at number 2, about a third of the way down the page, the definitions laid down in the following regulations shall also apply as appropriate, and 2BA applies the definitions in Regulation 882. And we will see in due course that the relationship between 882 and 854 is in essence this, that 882 are the general regulations, 854 supplements 882 by setting out some additional specific requirements for official controls in relation to products of animal origin. It can be seen, therefore, that 854 is intended, as we would submit, to work in combination with 882, and that is supported, if you look on page MS 829 at Article 1A of 854, this regulation shall apply in addition to 882.
Sorry, Mr. Hogman, page?
So this is 829, my lord.
Thank you.
At
Article 11A.
11A, yes. Thank you.
the purpose of 854, we submit, which is what we're looking at the moment, is not to detract from the general requirements in relation to official controls under 882, which we'll be coming on to in a second, but to supplement the official controls in 882 by providing some additional rules to take into account the specific aspects associated with food of animal origin, which is what we're looking at now. Now let me pause to make an observation in relation to the judgment of the Court of Appeal, because your lordships will recall that the judgment of the Court of Appeal attached importance to the fact that 854 in itself contains no provision for appeal, and the Court of Appeal said that that was, to use their adjective, striking. Not so, we respectfully submit, when you bear in mind that even the phrase official controls itself is not defined in 854, but is defined in the linked regulation 882. If the key definition of these official controls is in 882, it is hard to attach such significance as the Court of Appeal did to the fact that that is also where one finds the provisions for appeal. Now, going on in, and staying with 854 just for the moment, and going on in that, we come at 833, MS 833, to the requirement in Article 5 that official controls in respect of fresh meat take place in accordance with Annex 1. At MS 847, in fact it begins on 846, MS 846, that is where Annex 1 begins, and at 847 we see halfway down the page that Annex 1 mandates post-mortem inspection, and at MS 850, at the top of the page, as part of Annex 1, the requirement that if the inspection reveals the presence of a disease or condition that might affect public or animal health, the OV must so inform the business operator.
I'm just observing, as you're referring us to Annex 1,
Yeah.
these are duties specifically for the official veterinarian.
Yes.
It goes back to the point that we
Yes.
raised with you.
Yes.
And subparagraph 4 on page 850 sees that the official veterinarian must notify as appropriate the competent authority, referring apparently to them as separate entities. I just draw it to your attention as you go through. I know you're going to come back to it.
Yes. With respect, my Lord, whatever the, as it were, strategic view is in relation to the point that your Lordship has kindly raised, I'm not sure that paragraph 4 takes it very much further, because obviously the official veterinarian is not himself the competent authority, so it's hardly surprising to find them referred to as different.
Yes, thank you.
I would respectfully submit that that is neutral. So that is what we see in Annex 1. And just before we leave 854, just to return, please, to page 834 for a moment, MS 834, part of Article 5 itself, where we see that there is a requirement that a health mark be applied when official controls have not identified any deficiencies that would make the meat unfit for human consumption.
Sorry, where do we see that?
That is,
5.2.
yes, Article 5, paragraph 2, top of 8.3.
Top of the page, yes.
Page, yes. Our submission, our general submission in relation to the provisions that we've just been looking at, in 854 and to some extent the earlier ones, is that the process of inspection of the meat, the decision as to whether the meat is or is not unfit, and what we submit is the entirely consequential process of applying the health mark, in part at least for the purposes of traceability. So all those matters, inspection, decision as to fitness, application of the health mark, they are a part, and presumably a key part, of the official controls discussed in this regulation. And I make that point for a reason that will rapidly become apparent when we look at 882 and what is suggested to be the limited reach of 882. So 882 is at tab 4, suggested by our opponents. 882 is at tab 4, and as you see, concerns official controls performed to ensure the verification of compliance with feed and food law. And at 896, in Article 1, we see that the regulation is concerned to lay down general rules for the performance of official controls to verify compliance with rules aiming, among other things, at preventing risk to humans. I'll return a little bit later on to Article 1.3, the provision that 882 is to be without prejudice to specific community provisions concerning official controls. I'll come back to that. But on 897, you see that we have there the definition of official control at the top of the page under Article 2. Official control means any form of control that the competent authority or the community performs for the verification of compliance with feed and food law, animal health and animal welfare rules. And we submit that, so that's the definition of official control. At the bottom of the page, pick this up and then make a submission drawing it together. At the bottom of page at 10 is the definition of non-compliance, which means non-compliance with feed or food law and with the with the rules for the protection of animal health and welfare. And our submission is that contrary to the judgment of the Court of Appeal at paragraph 70 of their judgment, the legislation does not refer to non-compliance by the operator with any food law. The definition of non-compliance is broader, and it can occur irrespective of any specific human action or fault. It arises if the food is non-compliant with food law, in other words, if the food is unfit for human consumption, an issue which clearly cross-refers to or overlaps with the territory also covered by Regulation 854. And then looking at the operative parts of 882, first of all, of course, in the preamble at 894, paragraph 43 of the preamble, operators should have a right of appeal against the decisions taken by the competent authority as a result of the official controls, to be informed of such right. And then at 935, Article 54 starts. Chapter 1 of the regulation is headed National Enforcement Measures, falls to the bottom of 935. And Article 54 is headed Action in Case of Non-Compliance, and a range of actions are set out there, and I'll just touch on 2 or 3 of them. Firstly, at 1, when the competent authority identifies non-compliance, it shall take action to ensure that the operator remedies the situation. When deciding which action to take, the competent authority shall take account of the nature of the non-compliance and that operator's past record. Such action shall include, where appropriate, and then at B, the restriction or prohibition of the placing on the market, import or export of feed, food or animals, and at H, any other measure the competent authority deems appropriate. And then 3, the competent authority shall provide the operator with written notification of its decision and with information on rights of appeal and on the applicable procedure and time limits.
The reference to previous non-compliance, the past record, might suggest that this is referring to conduct on the part of the operator.
It might, and nobody is suggesting that there cannot be deliberate non-compliance, to which no doubt the operator's record would be potentially relevant. Our submission is that that does not in any way require one to take the view that non-compliance itself has to be deliberate. Non-compliance is separately defined, as we've seen, in a way that doesn't carry with it that imputation at all.
Thank you.
So in relation to Regulation 882, we would make the following key submissions. Firstly, we say that the regulation at 935 and 936, which we've just been looking at in Article 54, lays down a sequence of steps starting with the identification of non-compliance. Where this occurs, it is then mandatory, as one would expect, for consequential steps or measures to follow, including next, a measure restricting or prohibiting the placing on the market of the food in question, and finally, notification of the right of appeal. Non-compliance, restriction, appeal. So we say that's our first submission, that that's the sequence of steps. Secondly, the regulation cannot sensibly be interpreted as giving the regulator the option of providing a right of appeal, since taking together the preamble and the wording of the regulation as we've read it on 936, it is clear, we submit, that this is a mandatory requirement. Thirdly, the provision that this regulation is without prejudice to specific community provisions concerning official controls, and I said I'd come back to that. With regard to that, it is, we submit, inconceivable that that phrase can carry the weight attributed to it by the respondents and by the Court of Appeal. Crucial though it is to their argument to make that submission.
Could you just give us the page reference again? It's in Article.
That particular
896.
provision, it's at,
Article 1.3 at 896.
yes, so that is at,
It's all right, we've got it.
inconceivable that the phrase can carry the weight attributed to it by the respondents and heavily relied on by the Court of Appeal, crucial though it is to the argument against us for that submission to be made. The argument presupposes, as we submit, that the effect of that extremely general, indeed, if I may say so, rather vague language, is effective to exclude from a core part of the official controls regime, namely a decision as to the fitness of meat under Article 5 of 854, some or all of the key steps required in the case of identification of non-compliance. That, we say, is not a tenable interpretation. The effect is to exclude from a core part of the official controls regime, namely a decision as to the fitness of meat, and you'll recall that I emphasised that it is a core part of the regime, to exclude from a core part of the regime some or all of the key steps set out in 882 which we have looked at Article 54. And I say some or all because in fact it is entirely unclear to what extent the provisions of 882 Article 54, the sequence of steps, are to be disapplied in the case of this central issue of fitness of meat. Is it the whole of 854? Is it the whole of Article 54 which is to be disapplied? Or only the part relating to appeals? And how on earth could one make a determination of that question? And we will see, when we look at the manuals a little bit later this morning, that the FSA themselves have given different answers to that question as time has evolved. And as I mentioned earlier, and critically, a circumstance in which the regulatory decision depends entirely on the opinion of the OV, and where the FBO is not in any way at fault, is precisely the circumstance in which one would expect an appeal to arise. So, putting it in simple terms, they say that the decision as to fitness, a key part of the official controls regime, is unaffected to an unknown degree by Article 54, that Article 54 of 882 doesn't bite on that decision-making process, but which parts of Article 54 do or do not bite is unclear, and it is in any event improbable in the extreme that that is the correct interpretation. Now, we submit that it is perfectly clear why 882 is expressed to be without prejudice to 854. And I've hinted at the answer already. 882 creates, at Article 3, a general obligation in relation to official controls. This is on, I think we've looked at it already, but it's on 899, Article 3 of 882, on 899. A general obligation which requires member states to ensure, at the top of the page, 899, that official controls are carried out on a risk basis and with appropriate frequency so as to achieve the objectives of the regulation. However, that general obligation to carry out controls on a risk basis and with appropriate frequency naturally gives way to the more specific rules on official controls in 854, even though they may not be entirely on all fours with that general obligation. So, for example, under 854 Article 5, as we've seen, rules on official controls are created which require official controls to be carried out in accordance with Annex 1, and these are obligations under 854 which are more prescriptive than the general obligation in Article 3 of 882. Now, there is another difficulty in connection with the approach of the Court of Appeal, one which, if we may submit with great respect, they wholly failed to acknowledge. And this is going to lead us on into an important area for the purposes of our case. I mentioned just now that 882 Article 54 lays down a sequence of steps, including the third and last, which is the right of appeal. But equally important is the second step involving appropriate measures such as the restriction or prohibition of the placing on the market of the relevant food. Now, our case is that this general provision in 882 is reflected and has, since the inception of 882, been intended to be reflected domestically or in shall I say, in domestic legislation, in the provisions of Section 9 of the Food Safety Act 1990, which combines, as we will see, the restriction or prohibition in relation to placing on the market, and indeed destruction, if appropriate, which is the second of the three steps: identification, measures, and appeal. And the Food Safety Act also supplies the third step, the right of challenge, because that is achieved by the intervention of the Justice of the Peace. And incidentally, we will see that another, with great respect of the misconceptions of the Court of Appeal, was that Section 90 doesn't, as it were, give the Justice of the Peace the right to review the decision based on the expert evidence that the JP may receive, because it clearly does, and we will see that when we get to Section 9. Now, the respondent's case appears to be that it is open to them, and this is a key element in their case as to the inapplicability of Section 9. Their case appears to be that it's open to them to take action, that the measures as prescribed in Article 54 of 882 involve treating the carcass as animal byproduct. So they can require the operator to treat the carcass as animal byproduct. Indeed, it could be said that among the various pillars on which their case rests, that is a particularly important one, because if they cannot make that point good, then they fail to, as it were, succeed in displacing the applicability of Section 9. And I was going to mention the manuals again, but my lady has prohibited me from doing that.
I haven't done any such thing, Mr. Hopman. I just told you we knew about it.
So, can we please examine for a moment the submission that is made against us, has always been made against us in these proceedings, that the operator can be required to dispose of the carcass as animal byproduct. Of course, we're not dealing, and I just interpolate this point at this stage. In the vast majority of cases, if the OV identifies a disease and it is said that the carcass is unfit, the operator will agree voluntarily to surrender the carcass. He will cease to intend that it is used for human consumption, and then it can lawfully be treated as animal byproduct. But the key point is that under Article 3 of Regulation 1069 of 2009, and we'll look at it in a moment, but just let me make the submission first in general terms. Under Article 3, animal byproduct is defined as product which is not intended for human consumption. In this case, the slaughterhouse operator plainly intends the meat to be for human consumption. That is the whole point of the animal being slaughtered and undergoing operations at the slaughterhouse. There is a definition of slaughterhouse, again, we needn't go to it now, in Regulation 853. For reference, it's MS page 766. As an establishment used for slaughtering and dressing animals, the meat of which is intended for human consumption. And in addition, I'd remind you, and this is one of the reasons why I stressed it earlier, it's common ground that the meat of the carcass was food from the time that the animal was slaughtered onwards, up to and beyond the moment at which a decision as to the application of the health mark is made. It's not a live animal anymore. It's a product intended for human consumption. And the fact that there is an unresolved dispute about the meat's fitness for consumption does not change the operator's intention. In the absence of voluntary surrender of the meat by the slaughterhouse operator, at which point his intention changes, the operator still intends the meat to be for human consumption. It's still food, and it cannot be treated as animal byproduct. And perhaps, if I may, to save time, rather than taking you to it, I'll just give you the reference for the definition in the EU, the relevant EU regulation. It's in volume 2, tab 11, MS 1272. There are other indications that once something is food, it cannot lose its status as food, even if it's considered unfit for human consumption, not just the concession by the respondents. Article 14, which I referred to earlier, and I made the point earlier, demonstrates that even food which is unsafe is still food, food which is considered to be unsafe. That is in 178, Article 14, MS page 720. Food which is unfit for human consumption is still food within the legal framework. And that means, as we submit, that restricting its placing on the market or ordering its destruction can only be done under legislation such as 882, which regulates food. And indeed, we will see that an argument that says that these provisions in 882 and their equivalent in domestic legislation in the Food Safety Act, an argument which says that that doesn't apply to the decision about unfitness and to that which flows from the decision about unfitness, it is not only wrong in law, but it would be completely counterproductive from the point of view of the FSA or the OV or both, because it would restrict the powers which they have, and I'll come back to this, either to detain or indeed to require destruction of the carcass. Now, I'm moving towards the end of my submissions on the EU legislation and moving towards my submissions on domestic law. And my ambition was to do this by 11:30, so I think I'm at least vaguely on schedule. But before I do, maybe as a bridge from one section to the other, let me outline and perhaps invite your ladyships and your lordships to look at the way in which the EU regulations, when they came in 2005 or thereabouts, were dealt with by the introduction of consequential national measures designed expressly to enforce and execute the EU regulations, including 854. And this was initially in the form of the 2005 food hygiene regulations, then the 2006 food hygiene regulations, and latterly the 2013 regulations. And I'm going to go straight to the 2013 regulations, which are in volume 2 at tab 7. And we can look first perhaps at the explanatory note, which is on MS page 1204, and the relevant part is paragraph 3 on MS page 1205. where we see that at paragraph 3, that these regulations provide for the execution and enforcement of a number of EU instruments defined as the EU hygiene regulations. And those instruments include 852, 853, and 854. Then we can turn back, I should say, to page MS 1180 and regulation 25. Which tells us expressly that Section 9 on the inspection and seizure of food applies for the purposes of these regulations, and we'll see what these regulations means and how they link, how all the sets of regulations link together, applies for the purposes of these regulations, with the modification that it shall apply in relation to an authorised officer of an enforcement authority as it applies in relation to the authorised officer of a food authority. And I think the purpose of that, among other things, was to make it clear that the regulatory framework that previously existed in domestic law and in particular involved the authorised officer of a food authority, which I think was generally a local authority, that regulatory framework was now to apply in relation to an authorised officer of an enforcement authority, which includes the Food Standards Authority. That was the purpose of that. That provision may throw some light. I've taken a self-denying ordinance in relation to the point raised earlier by my Lord Lord Sales, but that may throw some light on what is believed or has been believed by everyone to be the answer to the point. Then we can go back further to page 1168, please, where we see Regulation 5 relating to enforcement authorities. And it's 5.2 which is relevant here, because we are a food business operator to whose operations both 852 and 853 apply. And it's provided that the agency shall execute and enforce the hygiene regulations insofar as the operator concerned is carrying out operations in relation to a slaughterhouse. So Section 9 applies for the purpose of these regulations. These regulations provide that the agency shall execute and enforce the hygiene regulations. And for the avoidance of all doubt, go back 2 pages to 1166. Where we can see in Article 2 of these domestic regulations, just over halfway down, that the hygiene regulations means these regulations and the EU hygiene regulations, and the EU hygiene regulations a little higher up means 852, 853 and 854. So by that unbroken process of cross-referencing, one sees that...
Sorry, perhaps just because we're there, we should also note Article 2.1, definition of authorised officer, just as we're going through.
Yes, thank you, Lord. By that unbroken sequence of cross-referencing, we see that the enforcement process involving the Food Standards Authority has its part, has as a component, we submit an essential component, Section 9 of the Food Safety Act 1990. Just one other reference, and again, to save time, I won't go to it, but we do have in the bundle some EU legislation prior to 2005. So, dealing with food safety law, there was a directive, for example, in 1964, Directive 64/433/EEC. This will be found, I'm not going to go there, in Volume 5, Tab 54. And at Article 7, which is on MS.
So, sorry, yes, MS. Yeah.
Yes, Volume 5, Tab 54. And by Article 7 at MS page 2219, it is provided that rights of appeal under domestic legislation continue unaffected by the provisions of the directive. To try to bring all these threads together a little bit before I move firmly into the domestic arena, our submission is that the EU legislation, on any view, allows for the possibility of appeal provisions in domestic legislation. And indeed, that much is accepted by the respondents and by the Court of Appeal, because the Court of Appeal has expressly accepted that by virtue of the 2013 regulations, in fact this is their explanation for its existence, the Section 9 procedure may apply, at least in those cases where non-compliance is or may be due to the deliberate act of the operator. We observe, however, that there is nothing in Regulation 25 or in Section 9 which restricts the application of the Section 9 procedure in that way. And it's interesting to note that in the bundles we do have a series of manuals. I shall come a little bit later when I'm dealing with the domestic position to the manual that subsisted for a number of years and which is wholly in alignment with our case. But just to pick up at this point, where I'm observing that I'm concentrating on what is conceded by our opponents, and if we could pick up Volume 5 for a moment. Take first, at tab 53, what is the current version of the manual, and the relevant page is 2210, MS 2210.
221,
2210.
thank you.
And this deals with the position where meat is said to be unfit. And if I take you first to the paragraph on 2210, immediately above the heading 3.5.2, So immediately above that, you see that their case is that if the FBO fails voluntarily to surrender, the OV must enforce under the animal byproduct legislation. I've spent a little time this morning explaining why that is misconceived and ultra vires. But it's worth noticing that immediately above that is a paragraph which says the OV should inform the FBO in writing where a dispute arises that the legislation requires the material to be unfit and disposed of as animal byproduct. See Article 54 of Regulation 882. And what are we to deduce from that? On any view, they accept that the requirement in 885 in Article 54 for the FBO to be informed in writing is applicable. And this is why I said that it's very hard to understand what the argument is in relation to Article 54. Even in the latest version of the manual, part of Article 54 is said to apply. And the case, with very great respect, lacks at any rate a degree of consistency. And
Sorry, you said this is the current one. What is the date of this?
This one came into existence after the hearing in the Court of Appeal. The manual, which was in being at the time of the appearance of my learned friend and I before the Court of Appeal, is in the previous tab 52. There is an index, which, in case your lordships want to check it later, the index tells you what these versions are, but just to inform you. So at tab 52, MS page 2194 is the relevant passage. Again, you see the somewhat surprising reference to Article 54 of 882, not something noticed by the Court of Appeal. There was a version which I think was in being at the time of the original hearing, which my learned friend conducted before Mr. Justice Simons then was, and the corresponding page is 2181. There's no reference there to 882, but there is a reference to the requirement to inform the FBO in writing. Very curiously, in this particular manual, just to pick up one final point, so this is the one that was applicable at the time of the first instance hearing. At 2174, please. We read as follows. Where voluntary surrender is not forthcoming prior to the meat having been health marked, the OV should declare the meat unfit and serve an animal byproduct notice requiring the disposal of the meat under the domestic animal byproduct regulations. Where the meat has been health marked and subsequently deteriorates and becomes unfit, and the FBO refuses to surrender the product, the OV must seize the food under the provisions of Section 9(3)(b) of the Food Safety Act 1990. So their view at that point in time, that's not the view that we take or that we submit is correct, but their view at that time was that Section 9 at least had applicability when the meat had been health marked and subsequently became unfit, which would appear to be an example of unintentional non-compliance. So at this point in time, and again, not noticed by the Court of Appeal. The Court of Appeal drew the line, as far as Section 9 is concerned, between intentional and unintentional, perhaps over-influenced, as we would submit, by the reference to the operator's record, to which my Lord Lloyd Jones drew attention earlier. That was the Court of Appeal's approach, differentiating between intentional and unintentional. But the FSA have, as it were, overridden even that distinction by referring here to an unintentional situation to which Section 9 applies.
Where do we find the dates of these different versions?
The best information that we have, I think, is probably to be found in the index. I think there is an index to this. So what we've looked at so far is 51, 52 and 53.
We don't have dates, though.
But no exact dates. I'm sure that with my learned friend's assistance, we can try and help the court further on.
Thank you very much.
I've been looking for examples of intentional and non-intentional non-compliance.
Yes.
In Regulation 882.
Yes.
Article 38 is headed Assistance in the Event of Non-Compliance. It's on MS 923. And the short point is there, it's talking about the goods not complying.
Yes, thank you.
Does that take us anywhere?
Seems to me consistent with the approach that we've been putting forward. I would respectfully agree. So, with those references, can I turn, please, to the second submission, the second and last submission, which I have to deal with, but this will undoubtedly take me until 12:30, or maybe a little longer. And what I propose to do is to show that starting as long ago probably as 1875, although we haven't gone back that far in the actual documentation, but as long ago as 1875, what we can see are two interlinked legislative strands in domestic law. The first strand provides primarily for the appointment of vets to carry out inspection of meat, and for what I would describe as consequential marking of the carcass. Obviously, you don't place a mark on meat which is unfit, but that is consequential and not primary. The second strand provides for the meat, if found unfit, to be seized and dealt with by a JP. Now, I hope it's helpful to have identified a route map in that way as we grapple with the domestic legislation. And we need to start, please, again in Volume 5, with the Public Health Regulations 1924, which are at tab 36. MS 1983. You can see that these regulations are made under the public health regulations, and that's why I mentioned 1875, which was, of course, the epoch-making Public Health Act of that year, which is where the story really starts. But we don't need to go back that far. We can see that these regulations centre around the role of a person called the inspector, defined in Regulation 2 on 1983, MS 1983, as the the medical officer of health or any other officer of a local authority having power under the Public Health Act to inspect and examine meat intended for the food of man. So you have two or three important points for our case emerge from that. Firstly, that the meat to be inspected and examined is meat intended for the food of man. Your lordships are aware of the importance that we attach to that. And we see that the inspector is defined as the medical officer of health or any other officer of a local authority having power to inspect and examine the meat. And we make the point, this is in part an answer to the approach of the Court of Appeal, and again, a fundamental premise of their approach was that because the OV is an expert, that means that, therefore, in some way, review by a justice of the peace is inherently and necessarily ruled out and inappropriate. Now, we submit that that is, with very great respect to the Court of Appeal, to, as it were, to convert an assertion into a legal proposition. There is no basis for saying that.
I mean, it goes a little bit further than review by a JP.
Yes.
I mean, we haven't come to Section 9 yet, but I had the impression that Section 9 makes the JP the primary decision maker.
Well, the ultimate decision maker only in those rare cases where there is a dispute. Yes, that is correct. Your Lordship, in saying that, and in confirming that as your Lordship's impression, is, by the way, supporting an important part of our case, because, of course, the Court of Appeal seemed to have great difficulty in accepting that Section 9 had any application at all. They were, I suspect, with great respect to them and indeed to my learned friends, rather led astray by the emphasis given to the health mark, and we'll see what they said in due course. Section 9 does indeed, I respectfully agree with your Lordship, Section 9 does indeed have that effect, and that's why it is applicable. That's precisely our point. But the other point that we make, but just based on 1983, is that, and if I can show, as I undoubtedly can, that the Section 9 procedure has, or something similar, has travelled alongside these provisions for inspection right from the very beginning, that shows that nobody thought that the Section 9 procedure, the power of the justice to review matters, was in any way inconsistent with the primary task of the inspector, or the OV as he now is, to bring his expertise to bear. And it may very well be that, as in so many cases these days before magistrates, that just to focus on this for a moment, we'll come back to it. This is a procedure that can be dealt with by a single justice, although it may be more than one. It can be dealt with, actually, we read in the FSA's manual, it can be dealt with on the site rather than in court. The justice can come out to the slaughterhouse if that's thought appropriate. And no doubt he would be heavily influenced by the expert material that was put in front of him. He wouldn't, in this day and age, he wouldn't be attempting to, as it were, be his own expert. But there would be the opportunity, and maybe the cases in which there was a full hearing would be rare, but there would be an opportunity for all relevant persons to be heard, we cover that, and for a decision to be made. And it's not in any way, it's never been thought to be inconsistent, and it plainly isn't inconsistent for there to be an issue which initially at least is susceptible to expert opinion on the one hand, but which ultimately is open to independent review on the other. So that's 1983.
And those regulations also provided for the marking of meat.
They did, my lady. Thank you. At 1986, that's absolutely right. Yes, yes. So again, there's nothing inconsistent with our approach to acknowledge, as we do, that if meat is fit, it's marked, and if it's not, it's not. It's consequential. Now, in due course, the primary legislation under which the seizure and decision-making of the JP was contained was in the Food and Drugs Act 1938, which is at MS 1990. I think it's the next tab, Food and Drugs Act 1938, and on MS 1991 you see the provisions in question, which are the precursor of Section 9. And I draw attention to this because the one decided case which is of some help was decided under this legislation. The decision was on a slightly different point, which we needn't spend time on, but in the case of Curley, which is in volume 4, please, at tab 34. MS 1968 is where it starts. There was a discussion in this case which doesn't arise now and probably isn't relevant any longer, because I think it's clear that the proceedings before the magistrate would be by way of complaint. I don't think that's in dispute. But what we do see in Curley on page 1969 are the facts which gave rise to the matter under the Food and Drugs Act 1938, where we see about halfway down the page that on October the 10th, 1955, 2 justices of the peace examined the meat at the abattoir, and after hearing evidence from the medical officer of health and the applicant, the justices, being satisfied that the meat was unfit for human consumption, condemned the same, and an order was made. So these are precisely the powers comparable to those now contained in Article 54, the measures that I mentioned in Article 54 of Regulation 882. And it is worth spending a moment, please. Sorry. Once again, to be a little critical of the decision of the Court of Appeal, but that's why I'm here. But if one looks in the core volume, please, at MS 223, and at paragraph 77 of the judgment. Towards the bottom of paragraph 77, MS 223, the court identifies the case and the actual holding in the case, but then the final sentence does suggest, with all respect, that the court was really misdirecting itself. Firstly, in saying there is no suggestion that the decision was founded in any way upon the public health meat regulations of 1924. Well, with respect, that can't be right. Insofar as the decision was based on the Public Health Act 1938, it was, of course, also based upon the powers contained in the public health regulations of 1924, which were applicable at the time, even though the report may not refer to them. But then there's this very puzzling comment. There is no suggestion in the report that a safety mark had been applied to the carcass. Now, that, I'm afraid we don't understand at all. Of course, there was no suggestion in the report that a safety mark had been applied. The circumstances were that no safety mark had been applied, and it was against the decision that the meat was unfit that the appeal to the justices was brought. Now, moving on swiftly, if I may, to review the rest of the legislation, and I'm going to abbreviate this to some degree. The 1938 Act was replaced, and I'm just going to give the court the references to some of these intervening provisions, if that's convenient. The 1938 Act was replaced by the Food and Drugs Act 1955, that's tab 39, MS 2005. The 1924 regulations were replaced by the Meat Inspection Regulations 1963, tab 38. MS 1992 is the key reference there. The 1955 Act was replaced in turn by the Food Act 1984, tab 41, and ultimately by the Food Safety Act. The 1963 regulations were replaced by the 1987 regulations, tab 40, then by the 1992 regulations, tab 43, and then by the 1995 regulations, tab 45, where one meets for the first time the specific role of the minister and of the OV. Now, taking, for example, the 1987 regulations, and if we could just look in volume 5 at MS 2010. There's a definition here which encapsulates the point that we're trying to make about the interlinked strands. You'll remember that I said that the interlinked strands were the appointment of vets to carry out inspection of meat and consequential marking, and secondly, for the meat, if found unfit, to be seized and dealt with by a JP. And here at 2010, in the 87 regulations, you read that an inspector is a person authorised or deemed to be authorised under the 1984 Act to act in relation to the examination and seizure of meat. One can see the same point even more clearly in the 1992 and 1995 regulations. So MS 2046, please. The 1992 regulations at Regulation 8, every local authority shall, in relation to any premises, appoint for each such establishment one or more official veterinary surgeons authorised to act in relation to the examination and seizure of meat to provide health certification. And in the 1995 regulations at 2095, where the minister comes in, again, Regulation 8/2095, the minister appoints veterinary surgeons to be an authorised officer of the minister authorised to act in relation to the examination and seizure of meat. So,
Mr. Hockman, I notice, I'm afraid going back to the 1938 Act.
yes.
because obviously somebody might be asking themselves, well, you've started with the 1924 regulations,
Yes.
but the 1938 Act,
Yes.
and you're saying that the two are linked.
Yes.
But I noticed that the 1938 Act was a consolidating act.
Yes.
We don't have enough of it to know what it was consolidating.
My lady, we have available copies of the relevant parts of the Public Health Act 1975. 1875, I should say. I wasn't entirely sure whether to burden the court.
Well, what I would like to know the answer to, but it doesn't have to be instantly, is what was being consolidated in the 1938 Act, and in particular, where did Section 10 thereof come from?
Yes. Thank you, lady. Well, again,
You can supply me with the answer after the short adjournment.
we will,
don't
but
need it
I
now.
strongly suspect that it will be simply a matter of looking at the relevant provisions of the 1875 Act.
It will be, yes. I'm sure you can do it very easily.
We have.
I don't want you to take up time now.
Thank you very much. I'll do exactly that. Thank you, lady. So, to reiterate, what we see is the two interlinked strands, inspection on the one hand and seizure and consequential review by a JP, long established, the inspection power always in expert hands. Of course, the inspection has to be carried out by an expert. Nobody would suggest otherwise. And the health marking regime also of long-standing but entirely consequential. And never suggested that the carrying out of the inspection by a medically qualified person is inconsistent with, in rare cases, the ultimate role of the magistrate. So now we can go to the Food Safety Act 1990, and I think the best reference to this is in Volume 1, Tab 6, MS 986. Where we find Section 9.
The MS number, sorry?
986.
Well, it starts at 985.
985, yes, thank you. Where we see that there is provision for inspection, which arises in the case of, this is subsection 1, inspection of any food intended for human consumption, and then three paragraphs within subsection 1, food intended for human consumption which has been sold or is offered or exposed for sale, is in the possession of or has been deposited with or consigned to any purpose for the purpose of sale or of preparation for sale, extremely wide language, or is otherwise placed on the market within the meaning of Regulation 178. We will explain in a moment or two the reason why paragraph C was introduced as it was in 2005. What we say just for the moment is simply that the language in section 9(1)(b), especially the language that makes the provision applicable to food intended for human consumption, which is in the possession of a person for the purpose of preparation for sale, is plainly applicable to the circumstances here, where the slaughterhouse has the meat and it is being prepared for sale, but of course it can't be sold until inspection and consequential health marking has taken place. And you will see then that under subsection 3, the authorised officer has two and only two choices. Either to give notice that the food cannot be used. This is in the case of food which is not deemed fit. He has two choices: either to give notice that the food cannot be used for human consumption and is not to be removed, that's A, detained for additional examination, which is provided for by subsection 4, or at 3B, he must seize the food in order for it to be dealt with by a JP. Completely clear from subsection 3 that the carcass remains food and not animal byproduct. And whether it is seized immediately or following detention and following the application of subsection 4, we then go to subsection 5, where an authorised officer exercises the powers conferred by 3B, which is seizure, or 4B above, which is seizure after detention. He shall inform the person in charge of the food of his intention to have it dealt with by a justice of the peace, there is express provision here for someone who might be liable to prosecution to be heard, maybe a former owner of the meat or something of that kind. But in any event, the business operator, as the recipient of the complaint, would be entitled to be heard. And then we get to subsection 6. If it appears to a justice of the peace, on the basis of such evidence as he considers appropriate in the circumstances, that any food falling to be dealt with by him under this section fails to comply with food safety requirements, he shall condemn the food and order the food to be destroyed or to be so disposed of as to prevent it from being used for human consumption. Any expenses reasonably incurred to be defrayed by the owner of the food. And then a provision for compensation in subsection 7, which again I'll come on to. Now, could we please look at the manual of official controls at tab 48 in volume 5, which is the manual which existed for a number of years until shortly before these proceedings commenced. And it's, as I say, at tab 48, and it starts at MS 2129. So we can look first at 2130 under the heading voluntary surrender. Where meat has not been produced in accordance with the hygiene regulations or is unfit for human consumption, the MHS should seek voluntary surrender of the meat. Voluntary surrender is an everyday occurrence within a slaughterhouse and should always be evidenced by completing a rejected meat receipt. This will identify the carcass, part carcass and offal, and should be issued for all routine matters and signed by the OV/MHI and a responsible member of the plant management.
And what does the MHS stand for?
MHS is MHS is Meat Hygiene Service, and MHI must be Meat Hygiene Inspector. An agreement to destroy food notice should be completed where any dispute arises or where issues are more complex. This agreement should be completed before the meat is consigned to the bin and is in addition to the rejected meat receipt. So that's the position under, in the case of voluntary surrender, which is by far the most common situation. That happened. It's quite significant in financial as well as in food safety terms. Then we can go on to page 2135. This relates to detention, and it's provided about halfway down the page that if the AO is not satisfied that the meat is fit for human consumption, then they should seek voluntary surrender of the meat for disposal as an animal byproduct. Where voluntary surrender is not forthcoming, and this is the FSA's position at the time, the OV must seize the food under the provisions of Section 9(3)(b) of the Food Safety Act as amended and take it before a justice of the peace or sheriff to be condemned. And then we can link that on page 2139 with the paragraph at the top of the page, 2139, where meat is clearly unfit and the FBO in possession refuses to voluntarily surrender, it can be seized using a seizure notice without the service of a detention of food notice, so no further investigation required, and an application for condemnation sought at the magistrates or sheriff's court. 2141, the second paragraph. In England and Wales, this is just advice as to how to go about it. In England and Wales, establish with the clerk, the magistrate's clerk obviously, a date, time and location for the court hearing. The location can be either the local courtroom or the plant, depending upon circumstances. The court date must coincide with the availability of the MHS legal representative, so liaise with MHS headquarters prior to serving the condemnation warning notice.
I notice that Scotland is a little bit more elaborate.
My lady, I think I should be completely open and say that we have not considered the position in Scotland in great detail, but we have ascertained that, broadly speaking, the position in Scotland is similar, and there are some regulations which apply. The Food Hygiene Scotland Regulations 2006, which are the equivalent of the 2013 regulations that we looked at.
Thank you.
We submit, looking at that manual, that on no sensible basis can it be suggested that this manual was issued in error or that it did not reflect long-standing practice. Nor is there any evidence by the regulator to that effect. Unfortunately, the Court of Appeal misapprehended this document too at their paragraph 79, again on MS page 223. when they said that the manual did not say, and it has not been shown, that the FSA has ever accepted that a justice of the peace has jurisdiction to reconsider a decision not to apply a health mark. With the utmost respect, that is simply wrong. The manual plainly imports and relies on the Section 9 procedure and puts the matter, in particular by Section 9, subsection 6, in the hands ultimately of the JP. And the fact that there's no reference to the health mark is straightforwardly because the application of the health mark, as I've repeatedly said, is consequential.
Yes, your position, as I understand it, is that the OV refuses the health mark, then asks for voluntary surrender.
Yes.
The FBO declines voluntary surrender, and then you say you get into Section 9 because there has to be detention or seizure.
Correct.
Yes.
And that not only fits perfectly with Regulation 882, Article 54, applicable as it is, working as it does in conjunction with Regulation 854, but it also fits entirely with Section 9. And it is precisely because the EU regulation process and the Section 9 process do dovetail and harmonise that Regulation 25 declares that the Section 9 procedure shall apply for the avoidance of doubt. As my Lord Sales pointed out, seems no doubt quite a long time ago now, since the EU regulations are directly applicable, the obligations therein apply in any event, but one can easily understand why, in the light of the domestic history, provision was made in the 2013 regulations and the earlier ones, 2005 and 2006, expressly to make clear that Section 9 was the relevant domestic process. And our submission is that this process has long been recognised to provide a safeguard for the food business operator, something which is, in those rare cases in which it is necessary, entirely unsurprising. And I make the point, insofar as I haven't already made it, that the framing of the 2013 regulations itself shows that everybody concerned thought that that Section 9 and the EU hygiene regulations were compatible and that there was no incompatibility between them. Certainly the Secretary of State who promoted those regulations and the FSA, who must have been consulted before those regulations were made, saw no incompatibility between the pre-existing domestic legislation and the directly applicable EU regulations that were coming into force. Now, it remains for me to deal briefly with some important points in relation to Section 9, which some of which have been, as it were, raised by way of objection or criticism. These points are very fully dealt with in our written case, I think starting at paragraph 56. But I do have a little bit of time. I have a few minutes to cover these points, so I'm going to do so, if I may, with as efficiently as I can. Firstly, dealing with the breadth of Section 9, as I've already submitted, the wording of Section 1B extends, we submit, to instances where food is in the possession of someone, in the possession of an FBO, for the purpose of preparation for sale, which encompasses the circumstances relevant to this case. And the Court of Appeal, again, with all due respect, were wrong to say that at the time of the inspection by the OV, a carcass cannot lawfully be held for the purposes of preparation for sale. That in itself would be a very odd proposition. The whole purpose of the operations at a slaughterhouse is to prepare carcasses for sale and then sell those carcasses, thereby furthering the effective functioning of the internal market. And the suggestion that until health marking takes place, the carcass cannot lawfully be held for the purposes of preparation for sale is inherently incorrect, we suggest, and illogical. Secondly, if and insofar as anyone is going to suggest, and I think the submission has been made, that the effect of the amendment which took place in 2005, introducing or adding subsection C to section 9.1, was in some way to change its meaning. We suggest that that is also illogical and incorrect. The insertion of subsection C came about, it was Regulation 11 of the General Food Regulations 2004, which I think in the bundle, and in a moment, since there is no question to which Mr. Hercop does not know the answer, I'll tell you where they are. But the section in volume 2, tab 8 it is. The reason for the insertion of paragraph C, subsection C, was because the EU regulations in their application were not limited to sale. They applied where there was any form of transfer, whether free of charge or not. And so the application of section 9 had to be widened accordingly. That was the only reason why C was introduced, as I understand it. And it would be very strange if the effect of that were to make the breadth of section 9 and the remit of section 9 any different from what it was before. It was not to narrow the scope of section 9, but in fact to widen it in that respect. And as I've submitted earlier, the attempt by my learned friends within this litigation, perfectly understandable, but nonetheless we submit incorrectly, the attempt, as it were, to narrow down the section 9 powers, to say that they only apply for instance, in circumstances where there's been intentional non-compliance. All of these things erode the powers of their own officers to seize and seek the disposal or destruction of food which does not comply with food safety requirements. Their approach is an interpretation which works against the objectives of food law. For example, if the Court of Appeal are right, an authorised officer has no power to detain or seize food of animal origin while it's undergoing preparation for sale, which would curtail their powers. Or if, for example, additional examination is required, which is something that is undoubtedly envisaged, by Regulation 854, and we saw that in Annex 1, Section 1.d. Then dealing briefly with the question of the right to be heard, I've touched on this already. Section 9 provides that a justice of the peace hears evidence which he considers appropriate. That's Section 9.6, which gives a broad discretion, and of course that means that the operator, among others, could be heard. Secondly, if we're right that the matter proceeds as a civil complaint, then the operator would be a defendant to the complaint and would be entitled to be heard and to call evidence. That's Section 53 of the Magistrates' Courts Act 1980, which is also in the bundle. Give you the tab reference to that in a moment. Volume 2, tab 16. And therefore, contrary to the judgment of the Court of Appeal at paragraph 74, which is MS page 222, slaughterhouse operator does not need to be charged before it can be heard and before it may call evidence. There is ample scope under Section 9 for the reasons that I've mentioned for the food business operator to be heard. And Section 9, subsection 5, which allows somebody to be heard, which expressly allows somebody to be heard who might be prosecuted, is not, as it were, is not all-embracing. It doesn't preclude other persons being heard as well. As I say, these points are all contained, and I am to a large extent cross-referring to our written case starting at paragraph 56. As to compensation, there seems to be some suggestion that that provision doesn't apply because this is in the Court of Appeal's judgment at paragraph 75, that provision doesn't apply because you would need primary EU legislation to enable to allow for a provision for compensation, but we respectfully disagree with that. The provision in Section 9 as to compensation is a perfectly valid one and not in any way inconsistent with the application of Section 9 in the circumstances that we put forward. There have been cases in this jurisdiction in which compensation has been awarded for wrongful state intervention. Some members of the court may remember the case of Mott against the Environment Agency, in which I appeared here a year or so ago, in which that was precisely the question. Finally, in relation to Section 9, I'd emphasise again a couple of points that Parliament has regarded the Justice of the Peace as an appropriate person to resolve these disputes for many, many years, and that there is nothing surprising in this day and age in allowing allowing technical and expert matters to be reconsidered by a magistrate, obviously taking into account and being no doubt heavily influenced by expert evidence one way or the other. And it's worth it's worth mentioning, and let me just provide the court with this little list. In the food law context alone, magistrates determine food hygiene prosecutions. This is all in our written case, so I won't trouble you with the references now, but food hygiene prosecutions, appeals against statutory notices on the basis that there's been a contravention of food law, procedures for hygiene emergency prohibition orders on the basis that there's a risk of injury to health, and procedures under Section 9, which could involve applications relating to substantial quantities of food. In all these cases, the magistrates, we say, are expressly empowered to consider these expert issues, which the Court of Appeal suggested was a reason why the procedure didn't apply. So that completes my review of the domestic matters, my second submission. The third submission, the backstop, I identified earlier, and I don't need to repeat what that submission was. That leaves only the fourth submission, and if I may, I will hand over to my learned friend to deal briefly with the EU Charter and the Human Rights Convention.
Yes, thank you.
My ladies, my lords, good afternoon. In relation to our fourth submission, we say that the rights under Article 1, Protocol 1 of the Convention and Article 17 just to restart the submission again. We say that the rights under Article 1, Protocol 1 of the Convention and Article 17 of the EU Charter mandate the application of some form of right of challenge to the OV's decision. And I propose to develop that submission, if I may, in three stages. First, to set out 6 legal propositions which we say can be derived from the Strasbourg authorities. Secondly, to demonstrate those authorities by briefly taking the court to some of the Strasbourg authorities, and for that purpose we'll need volume 4 of the authorities bundle, which commences at MS 1767, and then thirdly, and of course time permitting, to refer to 8 key features of the OV's decision in this case to measure this case against the principles which emerge in the Strasbourg authorities. So dealing first, if I may, with the legal propositions, the first proposition which we say can be derived from the case law is that for a measure which interferes with the property of a person to be justified, that is, to comply with the principles of lawfulness and proportionality, a person affected by that measure must be afforded a reasonable opportunity of putting a case for the purpose of effectively challenging that measure. And the decisions of the European Court refer to that in terms of an obligation or a constant requirement. Secondly, we submit that this procedural obligation applies regardless of which of the rules under Article 1, Protocol 1 is engaged, and regardless of whether the measure is categorised as a deprivation of property or a control of use. Thirdly, and contrary to the judgments below, this procedural obligation is not simply confined to regulate instances where domestic law has actually enacted a right of challenge. It also requires there to be a right of challenge against such measures. The fourth proposition relates to the nature of the obligation, and we would submit that the procedural obligation requires there to be an adversarial process that complies with the principles of equality of arms. Fifthly, that this process must enable the person affected by the measure to present arguments and to put a case in relation to the matter of dispute which exists. And then the sixth and final proposition is that in ascertaining whether those conditions are satisfied, a comprehensive view should be taken of the applicable procedures, And as with all rights under the Convention, the right of challenge must be practical and effective and not theoretical or illusory. Dealing, if I may, then with some of the Strasbourg authorities, and perhaps the first authority which I may take the court to, it's Authorities Bundle Volume 4, tab 29, which commences at MS 1809, and it's a fairly recent decision of the Grand Chamber from June of last year in GIEM against Italy. And as I say, this was a decision of the Grand Chamber from the 28th of June 2018. It was a case concerning the confiscation of property under Italian law. Applicant companies which had had their property confiscated for unlawful site development had no opportunity to challenge that confiscation measure. And the particular paragraphs of the judgment of the Grand Chamber appear at 302 and 303, and that's MS 1873. And to pick the judgment up, if we may, at the top of 1873, paragraph 302, in addition, the importance of the procedural obligations under Article 1, Protocol 1 must not be overlooked. Thus, the Court has on many occasions noted that although Article 1, Protocol 1 contains no explicit procedural requirements, judicial proceedings concerning the right to the peaceful enjoyment of one's possession must also afford the individual a reasonable opportunity of putting his or her case to the competent authorities for the purpose of effectively challenging those measures. Further down that particular page, the Court then went on to state an interference with the rights provided for by Article 1 of Protocol 1 cannot therefore have any legitimacy in the absence of adversarial proceedings that must comply with the principle of equality of arms, allowing discussion of aspects that are important for the outcome of the case, and in order to ensure that this condition is satisfied, the applicable procedures should be considered from a general standpoint. And then further down the page, the Court will see that the Grand Chamber went on to state that in addition, as the applicant companies were not parties to the impugned proceedings, they did not have the benefit of the procedural safeguards mentioned in paragraph 302 above. So we would submit that within those passages we see a number of the propositions at play. The first, the obligation. Secondly, the need for adversarial proceedings. And third, for those adversarial proceedings to focus, if you like, or allow a case to be put on the issues which are important to the outcome of the particular case.
And can you help us, why would the availability of judicial review that was talked about earlier on not meet those requirements?
Well, in our submission, that wouldn't be a practical and effective right to challenge what would be the issue in this case, which would be a dispute as to the OV's assessment of fitness. And in fact, at first instance, Mr. Justice Simon made that very point, that within those proceedings, he wasn't in a position to decide that particular issue. And that's core volume MS page 242. And that paragraph 9 of the judgment, Mr. Justice Simon stated, although the second claimant has placed material before the court which supports an argument that the animal was not suffering from pyemia, this is not an issue that I could or am asked to decide. So that's an issue which wouldn't be suited to judicial review, and judicial review, we would submit, wouldn't be in a practical and effective right of challenge.
I mean, I can see this in judicial review. The judge would be likely to afford quite a high margin of appreciation, for want of a better word, to the official vet. But the court would still be able to see if there were valid grounds for the official vet to have taken the view that he did, wouldn't it?
There may be, we would submit factual arguments in relation to the OV's assessment, which wouldn't be suited to resolution by judicial. That would be the first point. The second point would be in relation to the time frame. The Section 9 procedure is designed to be a summary procedure, which can be dealt with swiftly and expeditiously. Mr. Hockman's outlined the manual. whereby it's envisaged that the Justice of the Peace could even attend at the plant to deal with those types of issues. And again, in our submission, judicial review doesn't lend itself well to that type of required summary or expeditious procedure. So it's essentially for those two reasons which we would say that judicial review wouldn't provide a practical or effective remedy, hence the need for some form of right of challenge to that found in Section 9 of the Food Safety Act.
Thank you.
Turning, if I may, then to the second authority upon which we rely, the case of Denisova against Russia, which appears within the authorities bundles, volume 4, tab 28, and this is MS 1791. This was a case again concerning the confiscation of property. The wife and daughter of a defendant to criminal proceedings were not afforded a proper opportunity to claim their ownership of the property which had been confiscated from a defendant. And the particular passages within the judgment start at paragraph 55, please, if we may, which appears at page 1802. And the latter part of paragraph 55 states that the parties did not take a clear stance on the question of the rule of Article 1, Protocol 1, under which the case should be examined. The court considers there is no need to resolve this issue because the principles governing the question of justification are substantially the same, involving as they do the legitimacy of the aim of any interference, as well as proportionality and the preservation of a fair balance. So that supports one of the other propositions which we outlined, that these procedural obligations apply irrespective of which rule the particular interference is to be analysed under. Moving over the page to MS page 1803, paragraph 59, we see that the court talks in terms of the procedural requirement as a constant requirement that the domestic proceedings afford the aggrieved individual a reasonable opportunity of putting his or her case for the purpose of effectively challenging the measure. And then moving to paragraph 60, the court noted that in the instant case, the seizure and subsequent confiscation were ordered and carried out in a framework of criminal proceedings, and the applicants were not a party to those proceedings and had no standing in relation to them. Moving over the page, if we may please, to MS 1804, paragraphs 61 and 62. Two factors in our submission which caused the Strasbourg court some concern in this particular case is the fact that the applicants were denied an opportunity to effectively seek a finding on the merits of their claim, and secondly, that the court were precluded in that case from making any independent findings of fact. Then at 64, in the light of those considerations, the court found that the applicants bore an individual and excessive burden, which could have been rendered legitimate only if they had an opportunity to challenge effectively the confiscation measured, and as a result, the fair balance required had not been struck. The third and final authority, please, to take the court to appears at tab 32 of the same authorities bundle. It's MS 1940, and it's the decision in Micro Intellect against Bulgaria. And this was a case concerning the forfeiture of property. The applicant company owned alcohol, which had been forfeited under Bulgarian law, and the applicant company had no right to challenge that, notwithstanding that it was the particular owner of the alcohol in question. And again, at MS 1950, paragraph 44 of the court's judgment, we can see similar reasoning that applied in the previous two cases that we've looked at. This time, the court explained it that whilst Article 1, Protocol 1 contains no explicit procedural requirement, it has been construed to require. So again, the language of the Strasbourg court clearly talks in terms of this being a requirement. At paragraph 45, the court went on to note that the impounding and forfeiture of the alcohol was carried out in the course of proceedings against the sole traders, and it appears that under Bulgarian law, the applicant company did not have the opportunity to take part in those proceedings. And then further down the page on 1950, paragraph 47, moreover, neither the tax authorities nor the domestic courts were competent to determine who the owner was. And the court goes on to state that in the court's view, the lack of any judicial review of the contested measure was undoubtedly a result of deficient domestic legislation because the relevant law did not provide for such a review, which put the applicant company in a situation of having no safeguards capable to protect it against unjustified interference. And then at paragraph 49 of the judgment, MS 1951, the court states that having regard to those considerations, and in spite of the wide margin of appreciation afforded to the state, the court finds that the government failed to establish that the applicant company's inability to challenge the measure and the lack of any safeguards was necessary in a democratic society. So those three authorities, we say, illustrate the propositions which I outlined a moment ago. And then if one looks at the key features of the decision-making in this case and measures it against those authorities, we would submit that the state of affairs is such that there would be an infringement of Article 1, Protocol 1 and Article 17 of the EU Charter. Now, in terms of the key features of the decision-making in this particular case, we would invite the court to consider 8 features which we say encapsulates the decision-making of the OV. First of all, the decision compels the operator to destroy its business asset. The effect of the measure is to remove property from the operator. Secondly, the decision is solely dependent on one state official, the OV. Thirdly, the decision is solely dependent on the opinion of that one official. The fourth feature is that the financial loss to the operator arising from such decisions is significant, and it's an agreed position that in this case alone, the financial loss to the operator in relation to one carcass was approximately £2,000. The fifth feature is that the cumulative financial effects of this decision-making procedure could be even more substantial in any one case, owing to the fact that the opinion of the OV could compel, in effect, a slaughterhouse full of carcasses at any one time. Then sixthly, the wider effects arising from this decision-making procedure is that, and I refer to the respondent's own statistics in relation to this, and again, this is an agreed position in the statements of facts and issues, but the wider effect is that OVs are compelling the disposal of millions of pounds worth of meat each year, and therefore the annual interference by the state with the property of the industry is extremely extensive. And notwithstanding, and this is the seventh point, notwithstanding that level of interference, the OV's opinion as to the fitness of meat is immune from any challenge. The decision is final, and as we've seen, there's an absence of any safeguards or any measure of accountability. And then the final point, which relates to the factual circumstances within this matter, and this is the eighth feature of the decision in this particular case, is that the respondent was not prepared to engage in any dialogue, informal dialogue, as to the correctness of the OV's opinion. So our straightforward submission is that when one measures that factual position against the propositions which emerge from the Strasbourg authorities, we would submit that in the absence of procedural safeguards, in the absence of a right of challenge, there would be an unjustified interference with Article 1, Protocol 1 and Article 17 of the EU Charter. Unless I can assist any further.
No, thank you very much indeed. Brilliant timing. You've all got an extra 2 minutes until we'll return at 2 o'clock and look forward to hearing from the respondents then.